You can go through any conventional book, may it DD Basu or any such. Then you have JLEF, Justice, Liberty, Equality. We the people of India do hereby solemnly resolve to constitute India into a sovereign, socialist, secular, democratic republic. What do you mean by liberty? What do you mean by equality? What do you mean by fraternity? If you will do this only from concept, so there will be one question from concept in the prelims and one question would be from mains. Matlab, I don't want to give unnecessary gyan, but please understand, UPSC wants to recruit those people. Every now and then you will hear demand of exam. What all questions are likely to be asked in next 2, 3, 4 years when you are preparing?
UPSC doesn't punish less study, it punishes unchanged mistakes. If the same issues keep repeating, your prep isn't improving. It's just getting longer. Recall drops in mocks, answers stay generic, elimination errors repeat. Current affairs doesn't convert into mains points. These are signs your preparation needs correction. That's not an effort problem, it's a system problem. Vision IAS Delhi GS Foundation is built to fix this early. Sequenced classes, timely tests, built-in revision, mentorship reviews. PT 365 and Mains 365 make current affairs usable in answers. If UPSC 2027 is your target, start with a structure that makes improvement predictable. Batches starting from 3rd February at 8 am at GTB Nagar and 6th February at 11 am, 13th February at 8 am and 24th February at 5 pm at Karol Bagh. For more information, visit our website or call us on the given numbers.
Good evening. Is it audible at the back? Okay. Now, so we curated this session keeping in mind because already you are aware of other aspects of the preparation, like how about going with the sources, okay, and utilizing time to the best. Okay, all these things are quite mundane and conventionally communicated to you. So what we were thinking, how can we bring the best out of this session? So we thought that what we can do specifically, we can talk about the topics that have been conventionally appearing time and again into UPSC. Honestly speaking, I'm teaching for 9 years. This is my 10th year. Okay, September 2016. So what I have seen, ki at least 40-50% of the conversation, that is on a conservative estimate, at least 60-70%, okay, are the things which are repeatedly occurring. Okay, repeatedly occurring matlab same topics which are being asked again and again by UPSC. And if we see, I was going through that aspect also. Okay, so there are some conventional areas where UPSC asks question. One question which I often get, sir, should we refer to DD Basu, Subhash Kashyap, MP Jan, or any conventional book that is primarily referred for constitutional law? Okay. So you are yourself wise to understand that in UPSC you don't need those textbooks. Okay. Why? Because you have to write an answer in 250 words. Okay. That too in a short span of 8 to 8.5 minutes. So whatever you know, okay, you will not be able to reproduce the same. Okay, you have very little opportunity, so you have to be very precise. Here they don't need expert. Even in civil services notification, they have clearly mentioned that you need to stick to the what you call to the demand of the question and basic understanding of certain topics. Okay, so one thing is that few basic things. Okay, key, can we go with these sources? Okay, just a second, I'm completely messed up because I was stuck in a jam. Past 3-4 days I was not taking classes, having severe cervical pain, just because this session was scheduled. So we cannot postpone something which has been scheduled and widely communicated. So I thought, okay, at any cost I'll be taking, otherwise I'm not taking class for 2 days. Now if you look here, so one thing which I was talking about without, I mean, much ado, so can we refer to those textbooks? What I have realized, that first, you are not required to go through those textbooks. Okay, but yes, there are few conventional areas where conceptual question is asked by UPSC. If you see not last 10 years, if you see last 50 years question paper, then also you will find only 7 to 8 topics are there. From there, UPSC will frame conventional conceptual question. Okay, so conceptual question from where they will ask? They will ask from one, preamble. So this is one of the common doubts which I get from the students, sir, should be referred to these textbooks other than M Lakshmikant or Vision IS material. So nowadays in last few years have started saying ki, theek hai, you don't refer to these textbooks, but certain topics I am saying you can go through any conventional book, may it DD Basu or any such, because concept wise if you see, go through the question paper of last maybe 20-40 years, you will find there are few topics which they are asking from concept. Okay, one, they are asking from preamble. Okay, preamble may, for example, what do you mean by the term sovereign is relatively easy. Okay, so sovereign, socialist also they have hardly asked. Secular term, okay, secular democratic republic. Okay, then you have JLEF, justice, liberty, equality. We the people of India do hereby solemnly resolve to constitute India into a sovereign, socialist, secular, democratic republic, where justice, social, economic, and political, liberty of thought, expression, belief, faith, worship, equality of status and of opportunity, and fraternity, assuring the dignity to an individual and unity and integrity of the nation. Okay, so if you preamble, I feel is one such place where UPSC is asking conceptual question, both in mains as well as prelim stage of the examination. Prelims mein they have asked, what do you mean by justice? What do you mean by liberty? What do you mean by equality? What do you mean by fraternity? In mains, they have mainly asked questions from secularism. Okay, secularism or accountability or those things related to democracy. Okay, so for example, and being honest, there is a good aspect is that we live in an era of democratization of knowledge as well as information. So of course, primary sources are available so widely. For example, since childhood, you have heard the term of the people, for the people, and by the, even an e-rickshaw puller knows of the people, for the people, and by the people. But what is different with UPSC? Ki first of all, you should know when this was said, although UPSC will not ask fact, but just many a times you need information to arrive at knowledge. Okay, always understand there is a difference between information and knowledge. But information will help you to be a better knowledgeable person. Just in 30 seconds I'll explain. For example, if I want to travel from here to Nagpur, okay, first I will gather information that if I go by my own vehicle, this will be the time, comfort, cost. Aeroplane, time, comfort, cost. Train, time, comfort, cost. Walking, time, comfort, cost. Bus, time, comfort, cost. Sharing cab, time, comfort, cost. On the basis of that information, then I will take a decision, that is called knowledge. So there is a difference between information and knowledge. UPSC is not very much concerned with information all the time, but you cannot just come out as an intellectual person giving your opulence over language, writing two mesmerizing paragraphs without having information. So information is also very important, and it is quite unwise to say that only knowledge and intellectualism is tested. First, you need to have basic understanding of NCERT and those things. So many times I say this, trillion times inside the class, that your opulent over language will only be given an opportunity if you have information. So if you talk about collegium, everybody knows that. Even an e-rickshaw puller or a seller, a Golgappa seller at Old Rajendra Nagar knows that there is some issue going on related to the appointment of judges. Okay, he will also say that there is a conflict between judiciary and the government. But what you should know, that first you should have the fact. ठीक है भाई, Article 124, appointment of judges of Supreme Court. Article 217, appointment of judges of High Court. Article 233, higher judicial services. Article 234, subordinate judicial services, memorandum of procedure. First you have the basic requisite information. On that you can build your castle. Okay, so concept की जहां बात है तो preamble, Article 14, 19, 21 and 25. This they have asked repeatedly, especially Article 21 में वही हिसाब same every time. If you will do this only from concept, so there will be one question from concept in the prelims and one question would be from mains. Repeatedly from these topics only they are asking that what is due process of law, what is procedure established by law, what is equal protection of laws, what is equality before law. So these 4 articles, and undoubtedly Article 14 also is very important. I have already given the important ones. Okay, then we have DPSP, nothing. From Article 52, there shall be a President of India. 53, executive power of the Union, nothing conceptual, pure fact. To Article 61, impeachment of President. 57, President re-elected. 60, oath of the President. 62, 63, Vice President. Then you have all those things. You have 67, removal of Vice President. 74, Council of Ministers. 75, appointment. 78, duties of Prime Minister. All these things are factual. कोई conceptual question इससे कोई खास frame नहीं होगा. 79, Parliament of India. 80, 81, 82, delimitation से थोड़ा Article 82 you can see. Okay, 82 they can ask. Okay, otherwise then you will find conceptual question from judicial review. Even in appointment of judges, okay, there are basic questions. And what are the powers of Supreme Court? Appellate power of Supreme Court, Article 132, 133, 134, 136. Exclusive jurisdiction, Article 131. Federal dispute, Article 136. Special leave petition, 143. Advisory jurisdiction, 129. Contempt powers of Supreme Court, 137. हाँ, एक question पूछा UPSC ने, the difference between judicial review and reviewing its own judgment. अभी मैं क्या बोल रहा हूँ? I thought how I will go about this session. Okay, first those conceptual areas where repeatedly वही same area पिछले 40 years में if I go through 10 years तो YouTube पे available है. I have discussed 5 times. Last 10-year question, so I have discussed 5 times, and in the class I have discussed 10,000 times. So when I go through the question paper of last from 1979, UPSC started prelims, and even before 80s se to questions are easily available. Matlab, and mains question from 2013 when UPSC changed their pattern. Most of the time, few areas, wahi repeated areas se conceptual question they are asking. Okay, so fundamental right में तो conceptual. I'm not saying factual. Factual तो Article 18 से पूछ दिया. Maximum 3 Bharat Ratnas can be given in a year. Bharat Padma awards have been discontinued only once. ये सब तो हो गया. Factual question. Okay, one was per conceptual question. They will ask from 14, equality before law, equal protection of laws. 19, freedom of speech and expression, right to assemble peaceably without arms, right to form an association, union or cooperative, right to move freely throughout the territory. इसमें मेंस में क्वेश्चन पूछा कि what are the reasonable restrictions to move freely throughout the territory of India. फिर Article 21 is the favorite of UPSC. Due process of law versus procedure established by law versus principle of natural justice. जब हमें मालूम है, when we know कि यही 10 topics से conceptual question they are asking repeatedly, still if we will not do, it is not their mistake, it is our mistake. Okay, and I'm not saying they will ask too many questions. They only ask 14, 15 questions. 5 questions you will know. 5, 6 questions everyone will know who has ever prepared. We are only working hard for 4 to 5 questions in main stage of the examination, because polity se hardly they will ask 8, 9 questions. Else they will ask from IR, social justice and governance also I will include over here. So what is important? So and in prelims, so hardly 14 questions would be there. 5 you would know, 2 you would not be able to do. Whatever you do under the sky on earth, there will be some, nobody can score 200 upon 200. They will ask some factual question, which unless you have internet in the class, it is impossible to answer those questions. So with respect to that, आपको you have to work for those 5 to 6 questions which actually will decide whether you will sail through or not. तो सबसे पहले तो conceptual अगर aspect देखें तो ये judicial review UPSC has asked 2 trillion times. That what is the judicial review, and once they try to trap you between judicial review and reviewing your own judgment. गौर से सुनिए, this question trapped many students. UPSC asked the question that the high courts have the power to review their own judgment. This question was asked in 2022, which all the answer keys predominantly available. They gave this as a right statement. क्योंकि any court that has the power of judicial review, कोई भी ऐसा court which has the power of judicial review, any court that has the power of judicial review can review its own judgment. पर Constitution में it is explicitly mentioned for Supreme Court in Article 137 that Supreme Court can review its own judgment. पर High Court के लिए explicitly it is not mentioned in the Constitution. So UPSC ने आंसर की में उसका आंसर दिया no. High Court cannot review its own judgment, or Supreme Court ne, of course they have given. So and then UPSC asked a question that so they try to confuse you between judicial review and reviewing its own judgment. दोनों में अंतर है. What is judicial review? जो सुप्रीम कोर्ट डिफाइन करता है. जुडिशियल रिव्यू इज रिव्यूइंग द कॉन्स्टिट्यूशनल अमेंडमेंट्स, रिव्यूइंग द ऑर्डिनरी लॉज एंड रिव्यूइंग द एग्जीक्यूटिव एक्शंस ऑफ द गवर्नमेंट. Reviewing its own judgment का मतलब हुआ a judgment which has been delivered by Supreme Court, a review. जैसे 100 example, Sabrimala case, more than 50 review petitions have been filed. पंचायत फॉरेस्ट राइट्स एक्ट पे सुप्रीम कोर्ट का जजमेंट आया दैट इलीगल फॉरेस्ट एविक्टर्स शुड बी, ये इलीगल फॉरेस्ट डवेलर शुड बी एविक्टेड, उस पे रिव्यू पिटीशन फाइल हुआ. सो एवरी सेकंड डे यू विल सी अ रिव्यू पिटीशन बीइंग फाइल्ड इन सुप्रीम कोर्ट. रिव्यू मतलब एक जजमेंट जो ऑलरेडी दिया जा चुका है उसमें मॉडिफिकेशन की दरखास्त है. एनी जजमेंट विच हैज बीन डिलीवर्ड बाय द सुप्रीम कोर्ट देयर इज अ पिटीशन टू रिव्यू इट वर्सेस जुडिशियल review. So this term judicial review, this will you just see next year kya, after 12 years also you will see these terms will revisit in the question paper. Next you have separation of powers. Separation of powers is a very very generic term. Okay, generic term. So I will give you what they will exactly ask in separation of powers. Separation of powers mein what they expect you to know ki how the judiciary will safeguard against the tyranny of the state, against the tyranny of the state. एक छोटा सा example देते हैं. If you will take the question of last 40 years, UPSC has asked liberty sometimes. Okay, but in last 10 years, UPSC has asked liberty 7 to 8 times. So why they are only asking Article 21 and Article 22 liberty? Because there are so many petitions being filed in Supreme Court related to preventive detention, punitive detention, judicial custody, police custody, bail, payroll, procedure established by law, in last 10 years they have 7 to 8 times they have asked the question liberty related, kuch bhi related to arrest. Never ever UPSC asked what do you mean by arrest, what do you mean by judicial custody and police custody, what is Indian Prisons Act 1894, what is the difference between bail and fall law, whether a person under preventive detention is prohibited from being provided legal counsel. ये सब question last 10 years में पूछे हैं, and बार बार they are asking one term, constitutionalism. In fact, I am myself surprised that last year they asked constitutionalism. I was teaching in the class, I said इतनी बार पूछा है कि I think they are not going to ask again. So why they are asking constitutionalism and liberty time and again? Reason being simple, so many petitions are being filed in Supreme Court. हर दूसरे दिन मामला सिर्फ एक है, related to human liberty. From Sonam Wangchuk case to the arrest of a journalist, to matters related to detention of certain people, to certain people in custody without what you call proper trial. So every second day there is only one thing that is being in news that is related to human liberty. So again liberty terms and especially Article 21 and Article 22. So separation of powers में एक क्वेश्चन पूछा यूपीएससी ने 10 अक्टूबर 2021 का को प्रीलिम्स में 21 के, which of the following safeguards liberty? And the answer was separation of powers. क्यों? क्योंकि if the executive is arresting you arbitrarily, then it will be the judiciary that will save you from arbitrary arrest or detention. So this is separation of powers, judicial review 14, 19, 21, 25. Okay. Then if we move a bit forward, you see one thing which is the next uranium 238, that is federalism. Okay. So federalism, because you know federalism pe I can talk till tomorrow morning how many questions UPSC has asked from the role of CBI and ED, from the role of CBI and ED to the role of governor, to the approval of bills of the state by the president, to the relationship between center and state with related to financial matters. So anything that is related to federalism remains very, very important. I don't want to stretch this further. हाँ, कुछ चीजें, okay. Okay, so what is important, from that point of view? So these are the key areas where UPSC is asking you questions. Okay, so with respect to elections and there are federalism mein one thing I am not 99% sure, almost 100% sure कि most of the questions would be from this topic only. Most of the, out of 14, 5 to 6, 7 questions in prelims, and out of 9, 3 to 4 questions in mains from polity will be either from concepts in preamble 14, 19, 21, 25, judicial review, separation of powers and federalism. Okay, now we see, now one by one, let's see these things. Okay, that what UPSC. So we were having what to do. Now listen, if you are conscious, I don't want to give unnecessary gyan, but please understand, UPSC wants to recruit those people. Every now and then you will hear demand of the exam, but UPSC wants to recruit those people who have a lot of common sense, which I keep saying. So if I don't have time because this is just a 90-minute session, okay, if you will go through the question paper of last 5-7 years, they resonate what is constantly appearing in newspaper. Last year they asked a question, okay, a very, very important, I'll start with that, then I'll come over here. Last year, they gave a bouncer in the mains. They said, discuss the pardoning powers of American president with that of Indian president, which was the easy question. But the second part of the question was last May. It was a 15-marker question. So first part was, what is the pardoning power of American president with that of Indian president, which is relatively easy. Okay. Second part was, what do you mean by preemptive pardon? Preemptive pardon, which now has been discussed a lot. Now listen to me. Preemptive pardon conventionally was not, for that matter, not taught. It is conventionally not taught. Let me honestly acknowledge this. But let's type the term preemptive pardon over here. The first thing that comes is a news of the Hindu news article of 20th January 2025, where Joseph Biden, the president of outgoing president, has issued preemptive pardon. So this question was asked from newspaper. Okay, this question was asked from newspaper. So what do you mean by it? So UPSC conventionally wants students who are reading newspaper, they will have an advantage to those students who are just going through any secondary source. Current affairs material is exceptionally good. Without a shadow of doubt, it doesn't need a certification also from me, but it cannot replace the main course meal, that is newspaper. Now one thing, another question which UPSC asked that was related to okay. Now, of late, you must have the buzz. When we were graduating, at that time, the buzzword was MBA, Master of Business Administration. People used to say that anybody who is doing MBA will sail through. Okay. Nowadays, in judicial sector, you will hear one word, that is arbitration. So last year there was this judgment related to arbitration. It looks very complicated, but it's ultimate very easy. Okay, related to arbitration. UPSC asked the question. See those questions which are not conventionally found in any literature, which you will find as an answer after UPSC has asked a question in mains, then all the institutes suddenly they will start giving answer and very neatly left side this, right side. But after UPSC has passed that question. So after UPSC has passed that question, we don't go to the examination hall to learn anything. whatever we want to learn, we will learn before. So what I am trying to say, if you are throughout the year, if you are alert, जैसे arbitration को लेके a lot of discussion was going on last year. UPSC asked a question that what is the difference between lok adalats and arbitration tribunals, okay, which was actually an easy question, but it was a mains question. So newspaper remains the key important thing, okay. Now, so this question, because there was a judgment also delivered related to arbitration, okay, that is whether the court has the power to modify the arbitral award. This we discuss in the class also often, okay. So just wanted to emphasize the relevance of that. Now going back, preamble mein, I'll just touch upon these topics, okay. Preamble mein, for example, we have key terms, okay. Okay, so we have sovereign to sovereign, socialist, okay. Socialist is a very open-ended term. UPSC usually doesn't wither into those areas, okay. Sovereign, socialist, secular, democratic, republic, justice, equality. Okay, now that we know that these terms are frequently asked, now listen, there was a judgment given. अब देखिए questions कैसे आते हैं. One preemptive pardon appeared in newspaper. It was in the main stage of the examination. American Supreme Court ने एक landmark judgment दिया. हार्वर्ड फेयर एडमिशंस केस, बहुत उस जजमेंट का काफी डिस्कशन हुआ. स्टूडेंट्स फॉर फेयर एडमिशंस एंड हार्वर्ड यूनिवर्सिटी का वो केस था, ओके. ऑल्दो वी डोंट स्टडी अमेरिकन सुप्रीम कोर्ट जजमेंट, बट okay, but this judgment was delivered. Student for fair admissions versus Harvard, okay. UPSC ने question पूछा, discuss the principle of equality in American Constitution with that of Indian Constitution. So what are the key terms that are, I'm not talking about important things. Agar if something happens in America that is important, that also you can ignore. You have to pay attention if it is very important. And this judgment was widely talked about, that student for fair. So next year UPSC asked a question in mains, okay, that what is the, यही judgment आया, फिर UPSC ने question पूछा, that discuss the provisions of equality in American Constitution with that of Indian Constitution. So what you need to understand कि there is a mains में, there is mentioned in the syllabus comparing constitution. It is humanly not possible to compare 193 member states, okay. Repeatedly UPSC is asking वही 4-5 country, America, most importantly United Kingdom, sometimes France, and when they will ask for France, they will ask about secularism of the France with that of East. अभी ऐसे तो we saw अभी क्लास में 50 कॉन्स्टिट्यूशन we see, जापानीज कॉन्स्टिट्यूशन का आर्टिकल 2 प्रोसीजर एस्टैब्लिश्ड बाय लॉ हम देखते हैं. एकदम सबर करना है, ओके ओके. फॉर एग्जांपल वी सी मेनी थिंग्स, जैसे जापानीज कॉन्स्टिट्यूशन दो तो ठीक है भाई, आर्टिकल 21 ऑफ आवर कॉन्स्टिट्यूशन, आर्टिकल 31 ऑफ जापानीज कॉन्स्टिट्यूशन, तो हमारा है ना आर्टिकल, नो पर्सन शैल बी डिप्राइव्ड ऑफ हिज लाइफ और पर्सनल लिबर्टी एक्सेप्ट थ्रू अ प्रोसीजर एस्टैब्लिश्ड बाय लॉ, उनका भी है. अब जैसे जर्मन कॉन्स्टिट्यूशन, हमारे यहाँ बेसिक स्ट्रक्चर है. many scholars agree that basic structure का बहुत सारे डिबेट हैं. You have M.K. Nambiar, Dietrich Conrad, but ultimately Article 79 Clause 3 of German Constitution has a heavy influence on the origin of basic structure. Although इसमें भी debate है. Scholars like Falius Nariman differ, but most of the scholars are that in German Constitution it is written that an amendment to basic law, any amendment that affects federation or basic principles of Article 1 and 20 is inadmissible. So Parliament of Germany cannot amend Article 1 and Article 20, like the Parliament of India cannot amend those things which are basic structure of the Constitution. So there are many things that I am shouting from this so many years, when you talk about nationalism, then Rabindranath Tagore, I have said this 2 trillion times, that every basic scholar must know about Rabindranath Tagore's views on nationalism. nationalism. This I am saying from 2016. In 2015 also in Bihar Public Service Commission means they asked what are the Rabindranath Tagore's views on nationalism. In 2023 or 24 UPSC means they asked discuss the views of Gandhi ji and Rabindranath Tagore on nationalism. Okay, so what I'm trying to say ki pehla you need to keep track of newspaper, what is going on in the newspaper, and especially when we have topics like comparing constitution, us point pe if there is a major movement in some or the other country, if there is an election in France, if there is an election in United States, okay, so what is the point is this, then you should see. We are not here in this, we will what you see what all those things they are right anyways. So with respect to preamble, you see what is secularism. You should have broad idea about secular. We decided that this time we will not be wasting time on roadmap and all those things, because already you have so many sessions on road map. What are the key topics which are appearing for UPSC, and time and again they are appear. 70-80% of the question paper comprises of these topics. Okay, so for example you have preamble mein you will know about secularism. They have repeatedly asked secularism of the West versus secularism of the East, then that you should know, and basically what are the reasonable restrictions. Okay, these things. Then with respect to democratic, this will also be important in your governance ki bhai how the government is of the people, for the people and by the people. Jaise what is the difference? Jaise democracy, Supreme Court said that election should be free and fair. In Kyoto Holohan case, Supreme Court said free and fair election is the part of basic structure of the constitution. So there is a difference between free and fair. If, for example, the elections were free from any violence and people were allowed to vote in the manner they want, so election was free, but it was not fair. Free matlab I am free to vote for anyone. Fair matlab everyone has equal chance to win. So if the people voted for their favorite candidate whenever they wanted to, it is free. But after they have voted, the ballot boxes were changed. So it was free but not fair. Some places the dictator gives only two choices, that you have to choose among these two parties. So election is free, you can choose any one of them, but it is not fair because everyone doesn't have the chance to win the election. Similarly, of the people, for the people, by the people. For example, during the British period, only limited people were allowed to contest, for example, the election, or you have to choose between two foreigners. So the government that is there, it may be elected by the people, it may be working for the people. Getting my point? So the point is of the people, for the people, and by the people. By the people means it is elected by the people. For the people means that it is working for the people, and of is most important. It is the people who are contesting election, they belong to us. It is one of us who have contested the election. So the representative should represent the people and they must be one among the people. Many places in the constitution it is written from among themselves. Jaise election of the chairman of the district level panchayat likha from among themselves. So they cannot choose any outsider, they will choose one among them. So the government should be of the people, for the people, and for the people matlab it is dedicated to the people. A foreign government may be for the people but not of or by the people. By the people means elected by the people. Of the people matlab it is elected one among the people. So what are the various aspects of democracy? Now if we see republic, okay, isi se same these areas UPSC is asking questions. For example, these days UPSC has a favorite area of asking questions, discuss the various aspects of republic in our constitution. So first point, you know ki bhai ki head of the state is an elected person. So that is an easy fact that head of the state is an elected person. What is important? One, head of the state is an elected person. Sovereignty is divided. So sovereignty is divided. Matlab there is no privileged class in the society. Everybody will enjoy that sovereignty. Now listen, Republican as a concept has come, which is a declaration that we don't believe in kings and queens and prince and princess anymore. Republicanism is a declaration that the sovereignty which used to lie with the king, that sovereignty, that superiority is not with the king anymore, it is divided among everyone. Why do we announce awards only on the eve of Republic Day? Padma Awards always we announce on the eve of Republic Day. We don't announce these on the eve of Independence Day. Kyun? Kyunki we give the announcement of Padma Awards on the eve of Republic Day is a symbolic thing that the citizens of the country, there is a divided sovereignty. Everybody is celebrated. The title of His Highness, or for that matter, Sir, or for that matter, Rai Bahadur, or for that matter, Khan Bahadur, all these titles which create arbitrary distinction in the society, cosmetic, are no longer there, and every individual is equally important, and the society will celebrate merit not on the basis of birth but on the basis of their virtue and how they have achieved something in the society. That is why we announce these awards on the eve of Republic. So republicanism is not about head of the state being elected only. It is about having a divided sovereignty. There is no privileged class in the society. Everybody is equally treated and the merit is celebrated in the society. That is why we celebrate republicanism on the eve of Padma Awards on the eve of Republic Day. So then now these two concepts, equality ko leke to undoubtedly so many questions have been asked in prelims as well as in main. Substantive equality, procedural equality. So achieving equality in real sense, difference between equity and equality. See, justice does not mean equal. Justice means dispensing something which is due, which is just. For example, two people are fighting over this mouse, that this mouse belongs to A or B. I will give this mouse to the person who has actually spent his hard-earned money and he has bought this mouse. I will not say that 3 days you will use and 3 days you will use. So justice is not about equality. It is dispensing what is just. That is why we say, for example, Article 326, everybody having the right to vote is political equality. But Article 330, seats will be reserved for SC/ST in Lok Sabha, is political justice. And one of the most favorite lines of Dr. Ambedkar is that political democracy is a top dressing on Indian soil, which is essentially undemocratic. So if you just achieve political equality, or if you just achieve, so just giving everyone the right to vote may lead to political equality, but political justice will come when you will reserve seats for SC/ST in Lok Sabha, Article 330, State Legislative Assembly, Article 332. So if you will work upon these key areas, believe me, at least 50% of the questions you will directly locate that they are found in your prelims as well as in the mains, that what is justice, what is equality, what kind of justice we promote, substantive justice. Okay, then you have, there is one question which is impending, which will be asked today or tomorrow. Difference between vertical, now I'm saying this next year, you see. Very soon they will ask between vertical reservation and horizontal reservation. Okay, so this also, any reservation, any reservation which is on the basis of caste, which you can jump, okay, for example, SC, ST, OBC, which you can jump, is vertical in nature. Horizontal matlab irrespective of all these lines. For example, they're differently abled. So within all the criteria, you will have differently abled. With all the criteria, you will have women. Within all the criteria, you will have for ex-army men or in Agniveers and all those things which cut across the caste and religion lines, which are horizontal. So they may ask you a question related to that. Discuss the provisions of justice through some examples of horizontal reservation. So, or they say horizontal reservation is wider than vertical reservation. Agree? Do you agree or something? Do you agree that horizontal reservation brings more justice than vertical reservation? Or substantive equality is more than mere equality? These kind of question. So you see next year or even years after year, same kind of question, that what do you mean by justice? What do you mean by equality? Equal protection of laws versus equality before law. To chalo, they have asked so many times, what kind of justice Constitution of India? Jaise Dr. Ambedkar said, that political, social and economic justice. For example, on 26th January 1950, India became republic. Everyone was having the equal right to vote under Article 326 of the Constitution, and there will be no separate electorates under Article 325. There will be no separate voter list. So we achieved equality in the sense that the value of vote of every individual became one. But was there no economic inequality in the society? Was there no caste-based discrimination, untouchability? So political equality or political justice is not enough. You have to substantiate that with social and economic justice also. So isi sab ke around they will be framing question. Isse they will frame, you will be relatively more comfortable. But isse they will frame substantive equality, equity versus equality, provisions of horizontal reservation versus vertical reservation. What are the provisions of reservation in Indian Constitution constitution with that of American constitution? Do you think that the reservation has been able to achieve substantive equality? Critically analyzed. Okay, so justice is an illusion. Comment. Okay, so justice in what sense? Giving reservation, gender-based reservation to women is a form of justice, or what kind of justice is still to be done for transgenders? All these questions revolving around the idea of justice or equality. So first we have secular, democratic, republic, justice and equality, these key terms. Second topic we have, isme by and large it is 14, 19, 21, 25. Those already roadmap and all those things we have discussed so many times. Now you just go and check last 25 years question paper. Okay, last 25 years question paper mein, most of the time you will see from fundamental rights only these 4 articles are hovering all the time. That is 14, 19, 21 and 25. 14 say one question they asked 3 years back, ki if the legislature gives an arbitrary or unbridled power to the executive to make rules and all, which of the following articles stand violated? It was Article 14 of the Constitution, because Article 14 talks about reasonable classification. Now listen, I always say that Article 14 is like a salt. Any PIL that is filed in Supreme Court, just go and download, whether it is denial of entry to women inside the Sabrimala temple complex or in a Sufi shrine dargah. 2, Lily Thomas case declaring the section 8 subsection 4 of RPA 1951 as unconstitutional. 2, cases related to environment which were ruled by Supreme Court recently. Environment related cases रहे, CAA को challenge करना रहे, denial of entry to women inside a temple complex रहे, या decriminalization of politics हो, Association for Democratic Reforms versus Union of India electoral bond का case हो, you have odd event जो दिल्ली में चल रहा था, तो दिल्ली हाई कोर्ट में odd event को challenge किया गया था. Most of the time you will see first article which the petitioner will invoke in the Supreme Court or High Court is Article 14 of the Constitution. So Article 14 of the Constitution, you have equality before law and equal protection of laws. अब इसी के अंदर है substantive equality, like should be treated alike, unlike should not be treated alike. Those people who are placed in similar circumstances shall be treated similarly. Those who are not placed in similar circumstances shall not be treated similarly. Protective discrimination is a facet of equality. You should have a substantial understanding of Article 14 of the Constitution. कि what is Article 14, arbitrariness, reason. जैसे देखिए, Article 14 permits classification as long as it is reasonable. From Article 1 to 395, there is no provision for reservation for differently abled. In fact, there is no provision in the Constitution for differently abled except Article 41. Article 41 says the state to the best of its economic capacity shall take care of differently abled. Other than that, you will not, but still you have Right of Person with Disabilities Act, up to 3% reservation in non-technical services, which is horizontal reservation. So yahan pe it is a reasonable classification. If in CAPF sub-inspector constable level, we are reserving 10% jobs for Agniveers, it is a reasonable classification. So Article 14 permits classification as long as it is reasonable. 19 में there is a world, आना ही है क्वेश्चन, फ्रॉम सिनेमेटिक एक्सप्रेशन से लेकर हेट स्पीच से लेकर सेडेशन से लेकर सिनेमेटिक एक्सप्रेशन सिनेमेटोग्राफ एक्ट 1952 एज अमेंडेड टाइम टू टाइम, आईटी रूल्स से लेकर with respect to IT rules से लेकर you have cinematic expression, hate speech, then you have Shreya Singhal case, इसी में Shreya Singhal case भी आ गया. So many things related to Article 19 of the Constitution. 21 में basically they will ask 3 things: due process of law, procedure established by law, and principles of natural justice. This again they have asked this question 2 years back on principles of natural justice. 25 relatively is going to be easy. Okay, 25 may if they will ask a question, preamble may already you have studied about secularism, what are the reasonable restrictions and all those things. So in the fundamental rights part, these are, other than this you will not be I mean, trapped, because Article 15 and Article 16 is not that tough. Only one question they asked, Article 16 Clause 4, linking it with Article 335, which was discussed in the class. 17 is untouchability, 18 is abolition of titles, 20 retrospective criminal laws cannot be applied. All those things are easy. 23 is related to immoral trafficking, and 24 bonded labor and all. So mainly conceptual question agar aayega, so it will be from 14, 19. Repeatedly they are asking related to Article 25. Now this we have done. Okay. Now we have judicial review, extremely important. Principles of natural justice. Principles, you know what are the principles of natural justice? What are the principles of natural justice? Okay, बताइए. Nobody can be a judge of their own case. जो अभी यहाँ थार में और ये वो जाम लगाए सब लिख रहे हैं. These, I am sorry to disappoint those who are not serious about academics. Okay, so there is no problem. There are athletes also who are doing good, but don't disturb those who are actually serious. Now listen. So if you see, I was thinking after a thought we discussed ki which all topics that we can discuss. So if you see this preamble, then you have 14, 19, 21 and 25. 25 say they have asked question in mains also, but 25 is easy. Mostly they have trapped student in 14 and 21. 14, principle of equality, equality before law, equal protection of laws, what you call so many things. And Article 21, procedure established by law, due process of law, principle of natural justice, substantive equality in Article 14. 19 is voluminous but not conceptually too overloaded. 25 again is voluminous but not too much overloaded. Okay, then we have judicial review. Okay, now if we see judicial review, undoubtedly, if you see last 70 years, one topic which has been consistently asked by UPSC, that is judicial review. Judicial review, first of all, the term judicial review is not mentioned in the Constitution. What is a review? What is review? Review means you wrote an article, you showed to one of the faculties and he evaluated your article. So actually he is reviewing your work. I wrote an article, I submitted to one of the professors at the college, and he will review my article or she will review my article. So first, the term judicial review is not mentioned in the Constitution. One. Second important thing, but so many places in the Constitution, indirectly there is a hint of judicial review. सीधी बात है, without judicial review, the Constitution would be of no significance, because promises are nothing unless you have some rule to implement them. पूरे Constitution में Article 1 से 395 तक किसी भी आर्टिकल को डॉक्टर अंबेडकर ने नहीं कहा that it is the very heart and very soul of the Constitution. From 1 to 395, सिर्फ एक आर्टिकल को he said it is the very heart. He said very 2 times. It is the very heart, and again he said it is the very soul of the Constitution, and he was talking about Article 32 of the Constitution. So why he said that it is not only the very heart but also very soul of the Constitution? He was talking about Article 32, and there is no other article as important when it comes to judicial review than Article 32 of the Constitution. Then fundamental rights would be nullity. उनका कोई अहमियत नहीं रहेगी. Fundamental rights would be nullity without what you call fundamental rights would be of no significance without what you call their implementation. So if the state is violating your fundamental right, you have judicial review. Now listen. One, judicial review term has been asked by UPSC almost every year, directly or indirectly. Second, ये Constitution में nowhere in the Constitution from Article 1 to 395 explicitly word लिखा हुआ है judicial review. ये term नहीं लिखा है. This question also has been exhausted and asked by UPSC that the term judicial review is not mentioned in the Constitution, which is लेकिन Constitution में ये लिखा हुआ है that all post-constitutional laws, the state shall not make any law which takes away fundamental rights, else it will be void to the extent of contravention. मैं हिंदी में बोलता हूँ, Article 13 Clause 2, कोई भी ऐसा लॉ बनाया जाएगा जो फंडामेंटल राइट्स को वायलेट करता है, तो जिस हद तक वो वायलेट करता है उस हद तक उसको वॉइड घोषित किया जाएगा. सो द स्टेट शैल नॉट मेक एनी लॉ दैट कॉन्ट्रवीन्स फंडामेंटल राइट्स, एल्स इट विल बी वॉइड टू द एक्सटेंट ऑफ contravention. So who will declare it void? Judiciary. So this article talks about judicial review. If the action of the state is violating your fundamental right, you can go to Supreme Court, Article 32. This article is talking about judicial review. Article 131 of the Constitution. If there is a dispute between center versus one or more states. B, center and one or more states on one hand versus one or more states. C, between two or more states. So again, if there is a state of West Bengal versus Union of India, state of Rajasthan versus Union of India, even in America, state of Texas versus federal government. So whenever there will be a central and state government, there will be a conflict. And who will solve that? Judiciary. So this is judicial review. Article 132, 133 and 134 on constitutional, civil and criminal matter. You can challenge the judgment of High Court in Supreme Court. That is judicial review. Article 136, you can directly go to Supreme Court against the judgment of any court. That is special leave petition. That is judicial review. So Article 226. The High Court will exercise the powers of writ powers. That is also a judicial review. So the term judicial review is not mentioned in the Constitution, but judicial review concept is provided all over the Constitution. Now, why do we need judicial review? अब if we don't have judicial review, अगर constitution में judicial review नहीं है, then the parliament will become supreme. Maybe parliament will make a law that nobody will speak after 6 p.m. Nobody will speak more than 250 words. To who will stop the parliament from becoming too powerful? It is judicial review. So judicial review is a very, very important element of checks and balances. Judicial review is very, very important. सबसे important point. Supreme Court said, what is the first basic structure? कहा rule of law, democratic form of government, republican character, federalism, secularism, equality, liberty, सब basic structure बाद में है. सबसे first basic structure है supremacy of the constitution. अगर constitution supreme है, so there will be separation of powers, there will be federalism, there will be rule of law, there will be democratic character, there will be republican mandate, there will be egalitarian setup, there will be welfareism, there will be judicial review. Everything will happen if you believe that it is not you or me who is supreme, it is the constitution. So what you need to understand, this very term judicial review, sabse pehle bhai, which are the articles related to judicial review. Second, they will use the, so which are the articles? Article 13, Article 32, Article 131, 132, 133, 134, 136, 143, to an extent 226, 227, all these articles provide for judicial review. किस article? दूसरा, why do we need judicial review? To maintain the supremacy of the constitution, to uphold the federal equilibrium, to protect the fundamental rights. What is judicial review? To review the constitutional amendments, to review the ordinary laws, to review the executive action. You can give 2 trillion example. Constitution amendment. 99 Constitutional Amendment Act was declared as unconstitutional on 16th October 2015 on Supreme Court Advocates on Record Association versus Union of India case. That is an example of judicial review. Section 66A of Information Technology Act 2000 was declared unconstitutional in Shreya Singhal case. That is an example of judicial review. So many executive actions of the state, the Supreme Court orders this, that vaccine will be provided to everyone, not only to those who are 45 plus, or so many judgments. That is an executive action which is challenged. That is an example of judicial review. Okay, next, impact. If you know impact, अच्छा, impact में you will also see through the prism of separation of powers. बहुत closely intricate है judicial review and separation of powers. For example, while exercising judicial review, the Supreme Court says कि नहीं भाई, within 500 meters of national and state highways, no alcohol will be sold. Okay, so people say नहीं, this is judicial activism, this is judicial overreach, this is promoting judicial supremacy. So how judicial review promotes judicial activism or overreach and impacts separation of powers? पहला. दूसरा, Suprio versus Union of India case में Supreme Court ने कहा people belonging to the same sex cannot marry. It is not protected under Article 21 of the Constitution. We will leave upon the government to bring a legislation, because marriage is in concurrent list. Maybe the government will constitute a committee headed by cabinet secretary. Supreme Court ने खुद नहीं कहा कि right to marry a person of same sex is protected under Article 21. इससे पहले court in Hadia case has already ruled that right to marry a person of your choice is protected under Article Hadia Shafi Jahan case under Article 21. So how judicial review has a relationship between separation of powers? इससे बहुत, it is an over, मतलब it is a very very important topic. अभी 2-3 और example. For example, I give कि भाई कोर्ट ने कहा कि अनूप बर्नवाल केस में कि the chief election commissioner will be appointed by a committee headed by Prime Minister, Chief Justice of India and leader of opposition in Lok Sabha. Within few weeks, government brought a law and replaced the Chief Justice of India with a cabinet minister nominated by the Prime Minister. So Supreme Court filled the legislative vacuum. उस वक्त कोई लॉ नहीं था तो लेजिस्लेटिव वैक्यूम फिल किया था. इट विल लॉ दैट वैक्यूम विल बी फिल्ड बाय द सुप्रीम कोर्ट. इट विल कंटिन्यू टू बी इन्फोर्स्ड टिल द टाइम पार्लियामेंट मेक्स अ लॉ. गौर से सुनिए. फॉर एग्जांपल, विशाखा वर्सेस स्टेट ऑफ राजस्थान. There was no law in India that specifically dealt with sexual harassment against women at workplace. तो कोर्ट ने विशाखा गाइडलाइंस दी, विच ऑल ऑफ यू नो, और लिख दिया दीज गाइडलाइंस विल बी इन्फोर्स्ड टिल द टाइम पार्लियामेंट मेक्स अ लॉ. तो बाद में पार्लियामेंट मेड अ लॉ, प्रिवेंशन ऑफ सेक्सुअल हैरेसमेंट एट वर्क प्लेस एक्ट 2013. सो दिस लॉ रिप्लेस द गाइडलाइंस गिवन बाय सुप्रीम कोर्ट. अभी तीसरा, 9 मार्च 2018 को एडवांस मेडिकल डायरेक्टिव लिविंग विल पे सुप्रीम कोर्ट ने गाइडलाइन दी और लिख दिया दीज गाइडलाइंस विल बी इनटू फोर्स टिल द टाइम पार्लियामेंट मेक्स अ लॉ. तो कई ऐसी चीजें हैं जहां सुप्रीम कोर्ट गाइडलाइन देता है टू फिल द लेजिस्लेटिव वैक्यूम, क्योंकि उस मुद्दे पर अभी कोई लॉ नहीं है. देयर इज नो लॉ. टिल व्हेन द लॉ कम्स, दैट वैक्यूम विल बी filled by the law. For the time being, these rules will fill that vacuum. That is also an example of judicial review. So the UPSC will ask you a conceptual question. They don't ask a direct question. They will ask you a conceptual question. They asked the question, liberty is absence of restriction, which was a wrong statement. D was liberty is to develop oneself fully. So same topic pe repeatedly they are asking question, judicial review, judicial activism, judicial overreach. All these terms are not defined anywhere under the sky as a finite statement. Different scholars may interpret differently. Even the term judicial review is not mentioned in the constitution. एक केस में कोर्ट ने यहां तक कह दिया, it is the constitution which is supreme. But we will say what is the constitution. It is the constitution which is supreme, but we will say what is the constitution because we are the final interpreter of the constitution. Now let me just tell you, although we have running short of time, but just 2 minutes. There are some places in the constitution where from day one, judicial review is prohibited. From day one, there are only Article 329, any law related to delimitation shall not be called into question in any court. Article 262, Parliament can exclude the jurisdiction from interstate water dispute. Parliament can exclude the jurisdiction of any court, including that of Supreme Court. And now we have part 9 related to Panchayats and 9A ULBs. These are the places where in the constitution it is explicitly written that the judiciary will not interfere. But last year I was taking PT 365 in current affairs. In one of the cases, court said, no, we will interfere if there is a manifest RB and there is a blatant violation of fundamental rights. अभी 2 example देके खत्म करेंगे. In Bihar Legislative Council expelled a member. He moved to Supreme Court. And Maharashtra also legislature suspended few members for 1 year. Okay. Both the cases, in that Bihar case, Supreme Court restored the membership of Sunil Singh ji, and in Maharashtra case, 10 or 12 members were suspended for 1 year. Their membership was also restored by the Supreme Court. Both the places we have Article 122, the proceedings of Parliament shall not be called into question in any court on ground of irregularity of procedure, and Article 212, the proceedings of state legislature shall not be called into question on ground of irregularity of procedure. Both the places, clearly the affidavit filed by the speaker or the chairman, as the case maybe, was that the court cannot interfere in the proceedings of legislature. तब भी court ने कहा, बोला judicial review is the basic structure of the constitution. तो delimitation हो या water dispute हो या suspension of the proceedings of state legislature हो, court cannot remain silent because it is the final upholder of the constitution. Oath leth, everyone's oath is different. President under Article 60 takes an oath that I will preserve, protect and defend the constitution and devote myself to the well-being of people of India. Judges takes an oath, I will uphold the laws and the constitution. This unique oath is only taken by the judiciary, that I will uphold the laws and the constitution. तो कोर्ट ने कहा ठीक है, लिखा हुआ है that we will not interfere, but we will interfere if there is a blatant violation of fundamental right. So in these questions you will take a very balanced approach. To what extent court, because there is no definition of the term judicial review, judicial activism, एकदम balanced approach रखना है कि too much is not necessary. अब बार-बार UPSC वही घिसे पिटे question, they will trap you. The Constitution of India defines basic structure. So there is no such definition of basic structure. The Constitution of India provides for judicial review to safeguard. It doesn't explicitly mention the term judicial review. But when it says that the court it will decide the matter between center and state, then actually it is talking about judicial review. So judicial review from the perspective of separation of, और ये एक ऐसी चीज है जो वर्टिकल और हॉरिजॉन्टल दोनों को अफेक्ट करती है. अभी फॉर एग्जांपल, relationship between center and state is vertical, it is federalism. But at center, relationship between judiciary, executive and legislature, this is horizontal. Judicial review एक ऐसा concept है जो दोनों में UPSC क्वेश्चन पूछती है. Relationship between center and state में भी on 8th of April 2025 state of Tamil Nadu versus governor of Tamil Nadu related to bills, federalism वाला क्वेश्चन भी पूछा, और फिर separation of powers between judiciary, executive and legislature, that is matters related to collegium. So judicial review एक ऐसा concept है जो separation of power which is horizontal को भी affect करेगा और federalism that is vertical को भी affect करेगा. Relationship between center and state, because article 131, any dispute between center and state, between center and one or more states on one side versus one or more states between two or more states will be decided by the Supreme Court. तो federalism को भी impact करता है और separation of powers. अगर if the local gunda was picked by the police but there is no station entry, article 22, he is not produced before magistrate within 24 hours excluding the, then his family members will move the high court. तो ये separation of powers को भी affect कर रहा है. और if there is a matter related to a bill between center, for example, Parliament passed 3 laws. Agriculture Produce Marketing Committee, Essential Commodities Act was amended, and then you had the laws related to contract farming, which was challenged in Supreme Court, which was a matter related to federalism. So judicial review, judiciary, दोनों जगह important है. Separation of power horizontal में भी, and also with respect to federalism, dispute between center and state. तो ये topic always you see most of the time these topic, this preamble पूछेगी UPSC 14, 19, 21, 25, then you have judicial review. Now we come to separation of powers. Just a second.
Most aspirants think revision means reading the same books again and again, highlighting lines, turning pages, hoping it sticks. But real revision doesn't work like that. Revision is not about rereading, it's about recall, connections and practice. If you can't recall an answer without opening the book, it won't help in the exam hall. True revision is about connecting concepts, simplifying them through mind maps, and strengthening recall with repeated MCQ practice. That's where structured revision makes a difference. The quick revision classes for prelims starting 20th January at 2 p.m. are designed exactly for this. Focused revision through core topics, smart consolidation, mind map based clarity, and MCQ driven practice. With 40 intensive classes, the program ensures complete coverage of high yield areas, helping you revise efficiently and recall with confidence when it matters the most. Because in prelims, success does not come from reading again. It comes from remembering faster and applying better. To know more, visit our website or call us on the given number.
You have judiciary, executive and legislature. Abhi of late, UPSC is deeply interested in quasi bodies. It is deeply interested in quasi bodies which perform judicial functions as well as administrative functions. They asked administrative tribunal, they asked lok adalas, they asked the role of election commissioner, they asked the role of officers during elections, they asked the provisions related to those tribunals, green tribunals. So quasi bodies which partially perform judicial functions and are partially perform administrative functions. Now listen, again separation of powers and federalism, because we have some time. Okay, federalism, so again it is a very, very voluminous one, but anyways. Separation of powers. सबसे पहले separation of powers में you should know separation of power at center as well as at the state. So at center you have Supreme Court, you have Council of Ministers and you have Parliament. क्या है भाई? Supreme Court Article 124, Council of Ministers Article 74 plus 75, and then you have Parliament Article 79 and related. State level पे you have High Court, you have Article 217, 14 में भी है, पर judges appointment 17 में. Then Council of Ministers Article 163 and 164, and then we have State Legislature Article 168, State Legislative Council 169 and all. Okay. Now listen, what all questions they are asking from separation of powers. जो सबसे ज्यादा पूछा है that is liberty. वही घुमा फिरा के वही सेम क्वेश्चन, दैट व्हाट इज द डिफरेंस बिटवीन पुलिस कस्टडी एंड लिबर्टी में व्हाट इज द रोल ऑफ जुडिशियरी. जैसे क्वेश्चन आया, लेट्स सी लास्ट 5 years also only, that if a person is under preventive detention, the Constitution of India prohibits the state from providing legal counsel to a person who is under preventive detention. If a person is illegally or arbitrarily arrested, where will his family members go? So if he is illegally arrested by the executive, then the family members will invoke judiciary. So separation of powers, how is the role of separation of powers in safeguarding the liberty? किसी स्कॉलर ने कहा what is the best definition of Indian state? वहां लिखा हुआ था secular state, democratic state, republic state, liberal democratic state. If you say liberal democratic state, it already includes a lot of other adjectives in it. So liberty of thought, expression, belief, faith and worship. So undoubtedly liberty में especially the role of judiciary and upholding the laws and the constitution, पहला separation of powers में. Second important separation of powers में, अच्छा एक और dispute आया वो we will see later. Second important thing with respect to the separation of powers is they will ask you about judicial activism. Of late, judicial activism कि कैसे judiciary is in a way judiciary is giving judgments. जैसे the court said कि alcohol will not be sold within 500 meters of national and state highways. Whether alcohol will be sold or not, this is core decision of the executive. But here the judiciary is directing the executive. So do you think the rising influence of judiciary in intervening in matters of executive is an example of judicial overreach or judicial adventurism? It itself is a big topic, but I will not go. So separation of powers में, अच्छा liberty तो itself में इसमें question पूछा, अब सुनिए 10 साल का ही देख लें. What is the difference between payroll and furlough? एकदम unique question. They asked the question on Indian Prisons Act. Again, a unique question. Most of the students were not able to answer. They asked the question, what is the difference between judicial custody and police custody? This was an ultra easy question. What is the difference between? They asked the question under Article 22, what is preventive detention and a legal counsel should be given or not? In last 10 years only, they have asked so many questions on liberty and linked that with the role of judiciary in safeguarding the liberty. Then we have judicial activism. कई बार जुडिशियरी गिव्स अ डायरेक्शन, जैसे 50 केसेस है सुप्रीम कोर्ट. अच्छा आर्टिकल 142 ऑफ द सुप्रीम कोर्ट, जैसे डे बिफोर येस्टरडे एक गरीब बच्चा इकोनॉमिकली वीकर सेक्शन का खुद से आर्ग्यू किया. ही वेंट एंड आर्ग्यूड इन द सुप्रीम कोर्ट दैट ही गॉट 530 आउट ऑफ आई थिंक 720 समथिंग इन नीट 540, एंड सुप्रीम कोर्ट ने आर्टिकल 142 एक्स्ट्रा ऑर्डिनरी पावर को इन्वोक करके डायरेक्शन दिया कि इस बच्चे को एक सीट मिलनी चाहिए. ओके इससे पहले देयर वाज अ स्टूडेंट फ्रॉम डिप्राइव्ड क्लास, ही वाज नॉट एबल टू सबमिट फीस ऑन टाइम, कोर्ट ने यूज किया आर्टिकल 142. सो एवरी नाउ एंड देन वन आर्टिकल विच हैज बिकम द मोस्ट important article of discussion, that is article 142, that is complete justice. Okay, so कैसे article 142, अब ये क्वेश्चन भी अभी आने जब आएगा तब नेक्स्ट ईयर बोलेंगे कि बोले थे कि the role of article 142 in has article 142 become a tool of judicial adventurism or judicial, क्योंकि article 142 को we call it is the ब्रह्मास्त्र of Supreme Court. Supreme Court can do anything under the troposphere, under the sky to do complete justice. कई बार आर्टिकल जैसे बहुत इतने केसेस हैं कि शाम हो जाए. राजीव गांधी जी was unfortunately assassinated on 21st May 1991. So the killers were in jail and they were not released because there was a provision in section 435 of CRPC that anybody, whether in any case which was investigated by an agency of the union, the state government cannot release that person without consultation with the central government. So in that case it was vacillating between center and state. Supreme Court ने article 142 use किया, लिखा we are using our powers under article 142 complete justice and directing the release of Perari Walan in case or in Rajiv Gandhi ji's case. Okay, so do you think that or chalo it was on humanitarian ground, but there are many cases where court has used article 142 and directed this and directed that. So how article 140 is article 142 the complete justice powers of Supreme Court diluting the separation of powers? क्या आर्टिकल 142 का यूज करके कोई कोर्ट कोई भी ऑर्डर दे रही है? सो दिस क्वेश्चन अगेन इज अ वेरी प्रोमिनेंट वेरियस एस्पेक्ट्स ऑफ लिबर्टी जुडिशियल. अब जैसे देखिए एक और चीज आई, The Supreme Article 361 of the Constitution, time immemorial, we have taught that no mandamus can be issued against president or governor. Article 361 says the president and governor shall not be answerable to any court in exercise of their official duties, and there is a settled proposition of law, which question was asked in 2025 prelims, that no mandamus can be issued against the president or governor. But on 8th of April 2025, in state of Tamil Nadu versus governor of Tamil Nadu, in a beautiful judgment, the Supreme Court said that no, the governor and the president are expected to take decision within the time frame. If they are not, then the parties can approach the court. So in a way, they hinted that they will issue mandamus, we command, to the president or governor. So it was in a way a violation of separation of powers, and also although it was a matter related federalism, because ultimately the governor is an agent of the center. So the role, time and again, to what extent the judiciary can deliver a judgment, they will be asking a question on separation of power. So इस पे आपको track लगना है. और last जो hot cake है, that is federalism. Now, मतलब I don't, it is not even required by me to say that federalism is important. Even if I don't say, you must know that federalism is very, very important. All these areas, just go and check last 50 years, how many times they have asked question. Almost 60% of the question, or 5 question, would be hovering from these areas. Only hardly 5 to 7 areas. A federalism itself. सबसे पहले तो federalism has 2 aspects. हमेशा याद रखना है, एक factual और एक current based. Factual is you shall know, you should know, you will know, you have to know. Okay, there is no doubt, and it is difficulty level pe, it is 0 upon 10. Okay, so what do you mean by the term federalism? Okay, इसमें what various scholars, Paul Appleby ने क्या कहा, Alexandrovich ने क्या कहा, Granville Austin ने क्या कहा, K.C. Weir ने क्या कहा, Dr. Ambedkar ने क्या कहा, what Supreme Court said in S.R. Bommai case, what is their opinion about federalism? So different. In fact, in your book it is written, somebody said Alexandrovich sui generis कह रहे हैं, कोई कह रहा है Granville Austin कह रहा है cooperative federalism है, कोई कह रहा है quasi federal है. Okay, Dr. Ambedkar has said so many things which I often read in the class also. Okay, Supreme Court on 11th March 1994 in S.R. Bommai case said कि ठीक है भाई, फेडरलिज्म इन इंडिया is not a matter of administrative convenience, it is an outcome of our ground realities. So federalism in India is not because India is too big a country to administer, that may be one of the reason, but in India it is also because of diversity. So पहले तो आपको पूरा factual मालूम होना चाहिए फेडरलिज्म का. टर्म कहां से आया, डिफरेंट स्कॉलर्स ने इंडियन कॉन्स्टिट्यूशन को कैसे कहा है, सुप्रीम कोर्ट ने क्या कहा है, डॉक्टर अंबेडकर जी ने क्या कहा है. देन लेजिस्लेटिव रिलेशन बिटवीन सेंटर एंड स्टेट, आर्टिकल 245 से शुरू होता है. देन यू हैव एडमिनिस्ट्रेटिव रिलेशन उसी के बाद. देन यू हैव फाइनेंशियल रिलेशन बिटवीन सेंटर एंड स्टेट. फाइनेंशियल रिलेशन में सबसे फाइनेंशियल रिलेशन, लेजिस्लेटिव एंड एडमिनिस्ट्रेटिव इज जेन 2. ओके, वेरी इजी, यू विल नॉट मेक अ मिस्टेक, आई नो दैट. फाइनेंशियल रिलेशन में यू विल मेक अ मिस्टेक क्योंकि यूपीएससी रिपीटेडली हैज आस्क्ड व्हाट इज आर्टिकल 268, आर्टिकल 269, आर्टिकल 269A बाद में ऐड हुआ, 270, 275 ग्रांट इन एड, 280 फाइनेंस कमीशन, 281 रिकमेंडेशन, 282 डिस्क्रिशनरी ग्रांट, 265 नो टैक्स शैल बी लेविड और कलेक्टेड सेव बाय द अथॉरिटी ऑफ लॉ, 266 कंसोलिडेटेड फंड ऑफ इंडिया पब्लिक अकाउंट, 267 कॉन्टिजेंसी अकाउंट, 265, 66, 67, 68, 69, 70. सबसे ज्यादा यहीं से क्वेश्चन आया है, 275, 280, 281 एंड 282. इतने आर्टिकल्स तो मालूम होने चाहिए. फाइनेंशियल रिलेशंस में मोस्ट लाइकली यू विल गेट ट्रैप्ड. ओके, इजी है, इफ यू स्टडी 1 or 2 times you will easily conquer the same. Okay, then we have easy part, that is national emergency, president rule and financial emergency. Okay, so ये तो factual हुआ. Now what is UPSC going to ask you? Okay, you are wise yourself to say what UPSC is going to ask. Okay, now you see what kind of questions can be asked from, just a second, from federalism. सबसे पहले रोल ऑफ गवर्नर. रोल ऑफ गवर्नर किस किस चीज में? पहला, अप्रूवल ऑफ बिल्स. Very, very important. It is a hot burning. Only reason why UPSC will not ask a question because they know everybody is ready. So Article 200 and 201 related to governor, and plus the state of Tamil Nadu judgment plus the advice given by Supreme Court in Article 143. Those who don't know, because this is an open session, many of you know but some of you don't know, so I often say in the class आपके लिए क्या क्या sources होने चाहिए. एक तो जैसे state of Tamil Nadu वाला judgment है, तो this I have said so many times. Okay, एक तो ऑप्शन है कि आप एससी ऑब्जर्वर पे जाएंगे. ओके, एससी ऑब्जर्वर पे वो केस भी आ जाएगा. ओके, दिस वाज अ प्रेसिडेंशियल रेफरेंस केस विच अराइज्ड आउट ऑफ अनदर केस, द स्टेट ऑफ तमिलनाडु. सो पेंडेंसी ऑफ बिल्स केस. ओके, सो यू कैन रीड ओवर द दिस थिंग, द जजमेंट गिवन बाय द सुप्रीम कोर्ट. So this was state of Tamil Nadu. So एक तो you can read the synopsis of the judgment at SC Observer. बहुत short में legal question क्या था और सुप्रीम कोर्ट ने क्या judgment दिया, SC Observer पे पढ़ सकते हैं. दूसरा, you have सुप्रीम कोर्ट judgment summary. अब सुप्रीम कोर्ट की अपनी वेबसाइट है, सेंटर फॉर रिसर्च एंड प्लानिंग, उसमें जो भी इंपॉर्टेंट जजमेंट्स होते हैं उस साल के, सुप्रीम कोर्ट उसका एक सिनॉप्सिस अपलोड करती रहती है. ओके, सो whenever the judgment is delivered, जैसे दिस जजमेंट वाज ऑन कोई भी एक्सपल्शन ऑफ, ये जो चैलेंज टू द एक्स मेंबर ऑफ लेजिस्लेचर, कोई भी फ्रीडम ऑफ स्पीच पे था, इस सब इसमें से यूपीएससी ने क्वेश्चन बनाया है. ऑलरेडी दे हैव फ्रेम्ड क्वेश्चन फ्रॉम हियर इन मेंस. ओके, फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन वाला जजमेंट था, फिर आर्बिट्रल अवार्ड वाला था. ओके, सो मोस्ट ऑफ द जजेस दैट जजमेंट्स दैट कम यू विल फाइंड ओवर हियर. सो दो सोर्सेज हो सकते हैं. ओके, एक तो एससी ऑब्जर्वर है जो मैं कई बार कहता हूं. ओके, तो पहला तो अप्रूवल ऑफ बिल्स है. दूसरा, अपॉइंटमेंट ऑफ वाइस चांसलर्स, इसको लेकर इशू हुआ है. तीसरा, प्रेसिडेंट रूल अंडर आर्टिकल 356 ऑफ द कॉन्स्टिट्यूशन. सो दिस इज देन वन सेकेंड, डिफरेंस ऑफ ओपिनियन बिटवीन गवर्नर एंड काउंसिल ऑफ मिनिस्टर्स, ये एक इंपॉर्टेंट है. आर्टिकल 164 का 163 का क्या इंटरप्रिटेशन है. नेक्स्ट इंपॉर्टेंट थिंग कि एपीजे अब्दुल कलाम टेक्नोलॉजिकल यूनिवर्सिटी. ओके, सो दैट जजमेंट वाज गिवन बाय द अपॉइंटमेंट ऑफ वाइस चांसलर को लेकर आया. देन यू हैव द व्हाट यू कॉल वेरियस, कुछ बिल्स नीट बिल्स और कुछ बिल्स वर व्हाट यू कॉल स्टॉप, वो तो स्टेट ऑफ तमिलनाडु का एक मामला था. देन वी हैव कॉलिंग ऑफ असेंबली सेशन. सो ये तो करंट अफेयर्स में एक तो हो गया. व्हाट आई एम सेइंग कि फेडरलिज्म में what all questions are likely to be asked in next 2, 3, 4 years when you are preparing. एक तो static aspect है फेडरलिज्म का जो आपको आना ही चाहिए. उसमें legislative, administrative, financial relation, national emergency, president rule, financial emergency, interstate council, interstate water dispute, zonal council, etc. उसके बाद सुप्रीम, what Dr. Ambedkar has said about federalism, Supreme Court has said, ये तो static है. अब करंट में सेंटर और स्टेट में जो डिस्प्यूट है वो किस है. सबसे पहले रोल ऑफ गवर्नर, दूसरा रोल ऑफ सीबीआई एंड अदर एजेंसीज लाइक enforcement, directorate, something. तीसरा, always the states have a problem related to fiscal federalism, especially how they are being compensated in the GST, financial relation between center and state. किन किन एरियाज पे आप कंसिस्टेंटली देखेंगे कि देयर इज अ डिबेट बिटवीन सेंटर एंड स्टेट. तो एक तो हो गया रोल ऑफ गवर्नर. गवर्नर भी भाई किस मामलों पर, अप्रूवल ऑफ बिल्स को लेकर, असेंबली सेशन को बुलाने को लेकर पंजाब में इशू हुआ था. देन अपॉइंटमेंट, डिफरेंस बिटवीन गवर्नर ऑन द काउंसिल ऑफ ministers, then you have president rule, then you have appointment of vice chancellors. दूसरा issue जो सब question आ चुका है, all these I have discussed, I have shouted, I have mentioned, and all these have been asked by UPSC so many times, and I am not saying this now, I am saying this for long, and they have been asked by UPSC. Okay, so that is related to CBI or ED. Then you have पैसे को लेके, nowadays a lot of issue between center and state related to finance commission, and you know that 16th finance commission, you know, Arvind Panagria sir. Okay, so 16 finance commission को also लेके recommendation हो गया. Then you, if you see the contemporary issue going, center और state को लेके बहुत सारे issues खुल गए. जैसे census को लेकर भी एक issue हो गया था. Surprising, census is at entry 69 in union list. Census Act 1948 is passed by the Parliament. So entry 69 है union list में, census act parliament ने pass किया है. So all such thing. Okay, okay. Then the Election Commission of India, conduction of special intensive, although this cannot be clubbed as a dispute between center and state, but undoubtedly many a time this has also become a point of friction, especially conduct of SI, are all such things. So anything that has come related to center and state, this to chalo I'm adding, I will otherwise keep this as an independence of Election Commission of India. So federalism में कैसे, पहले तो you should know कि all the static facts मुझे मालूम है कि नहीं, whether I know the legislative relation, executive relation, financial relation, national emergency, president role, financial emergency, interstate council, interstate water dispute, zonal council, role of governor, office of governor, general. दूसरा करंट इश्यूज जो चल रहे हैं, इसमें यूपीएससी ने क्वेश्चन पूछा 2021 के मेंस में क्वेश्चन पूछा, फिर क्वेश्चन पूछा रोल ऑफ गवर्नर, बार बार कंसिस्टेंटली दे हैव आस्क्ड अ क्वेश्चन, फिर फिस्कल फेडरलिज्म में दे हैव नॉट आस्क्ड अ क्वेश्चन, दे मे आस्क अ क्वेश्चन, ओके, ऑल्दो दे हैव आस्क्ड वन इनडायरेक्ट वन, ओके, सो दिस ऑल थिंग्स यू शुड, सेंसस दे हैव नॉट आस्क्ड, सो दिस साइमल्टेनियस होल्डिंग ऑफ इलेक्शंस वगैरह, चलो इट इज नॉट डायरेक्टली रिलेटेड टू फेडरलिज्म. सो नाउ व्हाट आई एम ट्राइंग टू ब्रिंग कि अगर आप इन टॉपिक्स को बस देखेंगे तो डेफिनेटली प्रीलिम्स हो या मेंस हो, if you will give 1 or 2 days to these topics only, so at least it is going to मतलब give you, this is, ये क्या है, this is relatively more proportional when it comes to mark. जैसे DPSP 100% there will be a question from DPSP, in spite of the fact that UPSC knows that nobody is going to make a mistake in DPSP. UPSC knows well that nobody is going to make a mistake in DPSP. Still, they ask a question from DPSP. क्यों? क्योंकि that is the only provision in the Constitution where the Constitution directly says these provisions are fundamental for governance. As a civil servant, what will you do? You will do governance. तो ये मुझे भी हंसी आती है, UPSC is asking that question which is easy, everybody answers, still they ask this question क्योंकि they are recruiting people who will be deeply involved in governance, and there is only one part, that is part 4, which directly mentions about governance. Article 37 says these principles are not enforceable in any court, yet nevertheless they shall remain fundamental in governance, and it shall be the duty of state to apply these principles while making laws. So DPSP से आएगा, लेकिन you will not make a mistake. That I know that most of the students will not make a mistake from DPSP and all those things. इसको छोड़कर सिर्फ 2 चीजें आपको अलर्ट रहना है जो मेंस में, when I was thinking about this lecture कि what all things extra, एक तो आपको इलेक्शंस को लेकर, और दूसरा दैट इज रिलेटेड टू व्हाट यू कॉल दिस थिंग, एक तो कंपेयरिंग कॉन्स्टिट्यूशन. ये 2 सबसे ट्रिकी होता है, इलेक्शंस एंड कंपेयरिंग कॉन्स्टिट्यूशन. अब इलेक्शंस में ये इसमें सब, आई एम ओनली फोकसिंग ऑन 2-3 काइंड्स ऑफ एरियाज. 1, conventional areas which you can easily do. Second, those areas which in current affairs you keep traps. Third, those areas where I know you are most likely to make a mistake related to elections and what you call the comparing constitution. See, we have paucity of time. Okay, not we, anybody under the sky. We cannot have polity lectures for 1 year. Okay, so we try to do our best. At the same time, इस टॉपिक को डिकोड करने के लिए कंपेयरिंग कॉन्स्टिट्यूशन, brutally most important topic related to current affairs. If Joseph Biden issued the preemptive pardon, UPSC asked the question. French presidential elections were held, UPSC asked the question, discuss and compare the elections French president with that of. So anything that happens, although Bangladesh and all, UPSC usually doesn't ask, but they may. जैसे अभी बांग्लादेश में इलेक्शन हुआ, क्या भाई, सो वहां 300 सीट्स हैं, प्लस आई थिंक 50 या 60 सीट्स हैं विमेन के लिए रिजर्व्ड है. 300 में आई सॉ कि 299 का ही रिजल्ट डिक्लेयर किया उन्होंने, 298, 99, एक सीट पे मे बी इलेक्शन वाज कैंसिल्ड. अब फॉर एग्जांपल बांग्लादेश नेशनलिस्ट पार्टी हैज वन 212 सीट विच इज अराउंड 70% सीट, 70 पॉइंट्स, 210 इन 70 समझे. सो बाकी ये जो विमेन की सीट है, इस पे कोई इलेक्शन नहीं होगा. Whichever party wins the seat over here, proportionately उनको ये सीट दे दी जाएगी. तो 42 सीट्स आउट ऑफ 60 उनको ऐसे ही मिल गई कि उसमें they can nominate women. So उन्होंने women reservation का क्या किया है कि they have kept the, ये सीट पे इलेक्शन डायरेक्ट होगा और जो इस पर जीत के आएगा, whoever wins this seat, they will be given proportionate seats in the national assembly related to women. So 60 सीट्स है women के लिए, तो इन्होंने 70% सीट यहां जीती, तो 70 मतलब 42 सीट्स they will be given over here, 42 women they can nominate. So there will be no direct election for women. The parties who win. अब एक यूनिक चीज किया उन्होंने, अब देखो पूछेंगे नहीं, but suddenly they have in the what you call past, they have asked Nepal, they may also ask बांग्लादेश. तो अभी रिसेंट इलेक्शन हुआ, वहां 2 इलेक्शन वाज इन 2 पार्ट. पहले इलेक्शन हुआ, यू वेंट एंड वोटेड फॉर योर मेंबर ऑफ पार्लियामेंट. दूसरा इलेक्शन वहीं पे एक रेफरेंडम बॉक्स था कि रेफरेंडम भी हो रहा था कि वेदर द कंट्री शुड हैव बाइकेमरल लेजिस्लेचर और नॉट. उसमें 6-7 क्वेश्चंस थे कि अभी वहां यूनिकेमरल लेजिस्लेचर है, ओनली देयर इज 1 हाउस, सो वेदर दे शुड गो फॉर टू हाउस, ये भी लोगों से पूछा. And any government that comes to power have to take a decision on the referendum within a stipulated period of time. So they not have asked, but at least you should, even if they don't ask, sometimes when you're talking about the in international relation unrest in South Asia, where you can use these facts to substantiate your arguments कि भाई इंडिया में यूनिकैमरल लेजिस्लेचर है, वहां बाई कैमरल की डिमांड हो रही है, इसी के लिए तो रेफरेंडम हुआ है दैट देयर शुड बी. वहां जैसे अभी विमेन रिजर्वेशन हमारे यहाँ आर्टिकल 330A है भाई, एंड 332A. 330A है लोकसभा में एंड 332A स्टेट लेजिस्लेटिव असेंबली आफ्टर नेक्स्ट डिलिमिटेशन. उनके यहाँ क्या है कि दे विल कंडक्ट इलेक्शन, और उससे जो जीत के आएगा प्रोपोर्शनेटली दे विल बी गिवन सीट्स. जैसे जो पार्टी यहां जीती, for example, they have won 70% seats over here, 70% seats over here, they will be given, they can nominate members who would be women members of parliament. So anyway, that is just an example. So इसमें comparing constitution सबसे unpredictable area होता है, okay, पूरे में, क्योंकि even in RPA 1951, if you will decently work for a day or two, you will prepare. उसमें वही कुछ घिसे पिटे articles, sections हैं, which I discuss in the class also. 123 corrupt practices, section 8 subsection 1, 2 and 3, subsection 4 लिली थॉमस केस. बट जो कंपेयरिंग कॉन्स्टिट्यूशन है, किस किस मेजर कंट्रीज में इस साल क्या क्या हुआ है, व्हाट हैज हैव हैपेंड इन दिस, कीप अ नोट एंड जस्ट कीप अ ट्रैक, एंड दे विल, यू विल मोस्ट लाइकली हिट द बटन बाय द ग्रेस ऑफ गॉड कि व्हाट काइंड ऑफ क्वेश्चंस कैन बी आस्क्ड. सो दिस वाज अबाउट द सेशन दैट वी वर हैविंग रिलेटेड टू areas. Those who have noted this down, you just from our experience, I am saying from last so many years, this many areas are asked by UPSC. If you have any question, you can ask. See, very easy. Listen, horizontal and vertical reserve, कुछ भी नहीं, basic concept है. Any reservation which is cutting across the caste, पहले तो basic समझिए. For example, there is reservation based on SC, ST, OB. C, getting my point, economically weaker section. Now listen, अब गौर से सुनिए. For example, if you are an SC candidate, so now you will be competing for SC seats. Now this is vertical reservation. I don't want, because this is such a beautiful topic, it will take ample of time, but I'm just want it to keep it very precise. Now you say, for example, there is a provision that all those who have worked as Agni Veer for 4 years, Agni Veers for 4 years will get some concession in constabulary and sub-inspector position in CAPF. Is this given to any SC, ST, EWS, or it is cutting across the caste? One. Second, for example, if unfortunately somebody is differently abled or visually impaired, so he will give reservation in all the criteria. Within SC, for example, 180 seats are for IAS. 180 ka, for example, 15% seats are for SC. 15% of 180. 15% of 180. So they have, for example, you have 18 plus 9. You have 27. So 27 if you have for that, SC. Within that SC coming from people with disabilities. उसमें 1 है disability, 1 है visually impaired, 2 differently able, 3 नहीं है, 4 है. Getting my point? Now listen. तो कोई भी ऐसा रिजर्वेशन विच कट्स अक्रॉस दीज बैरियर्स, उसका एग्जाम्पल क्या है? 1, पीपल डिफरेंटली एबल्ड. 2, अग्नि वीर्स. तीसरा, विजुअली impaired. Chotha, if for example we cannot give, the country always remain indebted to those people who have given life and give the supreme sacrifice, but some concession we can give to war widows. इस तरह के सारे रिजर्वेशन को we call horizontal reservation. Any other point? Although this is a very enticing point, but honestly speaking, you must know about 3-4 concepts. 1, equality, affirmative action, substantive equality, and equity. These 4 terms are going to trouble in the examination hall in mains. If you affirmative action, substantive equality, equality, and equity. Any other question you have? Else sir will have a session after this. Please. Okay, चलिए पहले क्वेश्चन कंप्लीट कीजिए. हाँ. Okay, now I did not. Now listen. One of your colleague is asking a question that horizontal reservation brings more justice. First of all, I never said that it brings more justice. What I said, both of them bring justice, depends upon necessary. It is equally important to have reservation for SC, ST and OBC, and it is equally important. One thing that is there, कि within the community, sometimes horizontal reservation brings more justice. गौर से सुनिए. For example, if you will have reservation for SC and ST, but you will not have reservation for differently abled. So कहा जाता है कि when it comes to caste and class, there are many research that are being done that many of the caste, class, sex, these are the three major discrimination. उसमें भी caste and sex. So many of the sex-based, gender-based discriminations are further accentuated by the caste. For example, a person, I don't want to spread that key. For example, a person gender-based discrimination is also due to caste. So what I am trying to say here, कि पहला कि reservation is necessary, but if you will not bring an horizontal measure, horizontal aspect of reservation, then you will not be able to do that complete justice. अभी example सुनिए. पूरे कॉन्स्टिट्यूशन में आर्टिकल 1, 2, 395 कहीं भी देयर इज नो प्रोविजन फॉर डिफरेंटली एबल्ड. बाकियों के लिए तो आर्टिकल 15 क्लॉज 5 है, सोशल एंड एजुकेशनली बैकवर्ड क्लासेस एंड शेड्यूल कास्ट एंड शेड्यूल ट्राइब. आर्टिकल 16 क्लॉज 4 है, बैकवर्ड क्लासेस ऑफ सिटीजंस नॉट एडिक्वेटली रिप्रेजेंटेड. लेकिन एक क्लासिएस्ट एग्जांपल, ट्रांसजेंडर. पूरे कॉन्स्टिट्यूशन में आर्टिकल 1, 2, 395 कहीं पे ट्रांसजेंडर मेंशन नहीं है. इट वॉज नेशनल लीगल सर्विस अथॉरिटी ऑफ इंडिया केस में सुप्रीम कोर्ट ने कहा ट्रांसजेंडर्स आर थर्ड जेंडर. अभी कुछ स्टेट ने इंडिया के क्या किया है कि फॉर ट्रांसजेंडर्स कांस्टेबल में 1.5% सीट्स विल बी रिजर्व फॉर ट्रांसजेंडर्स इन कांस्टेबुलरी. अगर आप उनको जॉब नहीं दीजिएगा, इफ यू नॉट गिव देम जॉब, हाउ विल दे बिकम पार्ट ऑफ मेन स्ट्रीम. आई एम सेइंग कई बार वर्टिकल रिजर्वेशन इज नॉट एबल टू डू जस्टिस. यू ऑल्सो नीड टू सब्सटैंशिएट इट विथ और. एक बात बताइए, इफ द रिजर्वेशन इज गिवन 1.5% टू ट्रांसजेंडर बिलोंग टू SC, ST, OBC, अनरिजर्व, जनरल, विच कम्युनिटी? इट कैन बी SC, इट कैन बी ST, इट कैन बी OBC, इट कैन बी. तो कुछ स्कॉलर्स कहते हैं कि सिर्फ वर्टिकल रिजर्वेशन, आई एम नॉट सेइंग वन विल डू मोर जस्टिस, आई एम सेइंग वन विल डू कंप्लीट जस्टिस. जल्दी बोलिए, वी हैव अ सेशन नाउ. एनी अदर क्वेश्चन? जल्दी बोलिए. Okay, so sir will be having another session. I was told कि road map वगैरह already you have ample of road map. मैंने कुछ topics दे दिए हैं. Most likely, honestly speaking, most likely these areas you are going to encounter, and you will yourself go and see the question paper of last 20-30 years. Consistently these areas come. So we will continue with the conversation. Thank you.